Rules on Civil Procedure, Rule 15, Motion, Section 1. A motion is an application for relief other than by a pleading. Section 2. Motion must be in writing. All motions shall be in writing except those made in open court or in the course of a hearing or trial. A motion made in an open court or in the course of a hearing or trial should immediately resolve in open court after the adverse party is given the opportunity to argue his or her opposition thereto. When a motion is based on facts not appearing on record, the court may hear the matter on affidavits or depositions presented by the respective parties. But the court may direct the matter to be heard wholly or partly on oral testimony or depositions. Section 3. Contents. A motion shall state the relief sought to be obtained and the grounds upon which it is based, and if required by these rules or necessary to prove facts alleged therein, shall be accompanied by supporting affidavits and other papers. Section 4. Non-litigious motions. Motions which the court may act upon without prejudicing the rights of adverse parties are non-litigious motion. These motions include A. Motion for the issuance of an alias summons. B. Motion for extension to file an answer. C. Motion for postponement. D. Motion for the issuance of a writ of execution. E. Motion for the issuance of an alias writ of execution. F. Motion for the issuance of a writ of possession. G. Motion for the issuance of an order directing the sheriff to execute the final certificate of sale. And H. Other similar motions. These motions shall not be set for hearing and shall be resolved by the court within 5 calendar days from receipt thereof. Section 5. Litigious motions. A. Litigious motions shall include 1. Motion for bill of particulars. 2. Motion to dismiss. 3. Motion for new trial. 4. Motion for reconsideration. 5. Motion for execution pending appeal. 6. Motion to amend after a responsive pleading has been filed. 7. Motion to cancel statutory lien. 8. Motion for an order to break in or for a writ of demolition. 9. Motion for intervention. 10. Motion for judgment on the pleadings. 11. Motion for summary judgment. 12. Demurrer to evidence. 13. Motion to declare defendant in default. 14. Other similar motions. B. All motions shall be served by personal service, accredited private courier or registered mail or electronic means so as to ensure the receipt by the other party. C. The opposing party shall file his or her opposition to a litigious motion within 5 calendar days from receipt thereof. No other submissions shall be considered by the court in the resolution of the motion. The motion shall be resolved by the court within 15 calendar days from its receipt of the opposition thereto, or upon expiration of the period to file such opposition. Section 6. Notice of hearing or litigious motions. Discretionary. The court may, in the exercise of its discretion, and if deemed necessary for its resolution, call a hearing on the motion. The notice of hearing shall be addressed to all parties concerned and shall specify the time and date of the hearing. Section 7. Proof of service necessary. No written motion shall be acted upon by the court without proof of service thereof, pursuant to Section 5, letter B hereof. Section 8, Motion Day. Except for motions requiring immediate action, where the court decides to conduct hearing on all litigious motion, the same shall be set on Friday. 9. Omnibus motion. Subject to the provisions of Section 1 of Rule 9, a motion attacking a pleading, order, judgment, or proceeding shall include all objections then available, and all objections not so included shall be deemed waived. Section 10. Motion for leave. A motion for leave to file a pleading or motion shall be accompanied by the pleading or motion so to be admitted. Section 11. Form. The rules applicable to pleadings shall apply to written motions so far as concerns caption, designation, signature, or other matters of form. Section 12. Prohibited motion. The following motions shall not be allowed. A. Motion to dismiss except on the following grounds. 1. That the court has no jurisdiction over the subject matter of the claim. 2. That there is another action pending between the same parties for the same cause. And 3. That the cause of action is barred by a prior judgment or by a statute of limitation. B. Motion to hear affirmative defenses. C. Motion for reconsideration of the court's action on the affirmative defenses. D. Motion to suspend proceedings without a temporary restraining order or injunction issued by a higher court. E. Motion for extension of time to file pleadings, affidavits, or other papers except a motion for extension to file an answer as provided by Section 11, Rule 11. And F. Motion for postponement intended for delay except if it's based on the act of God, force majeure, or physical inability of the witness to appear and testify. If the motion is granted based on such exemption, the moving party shall be warned that the presentation of its evidence must still be terminated on the dates previously agreed upon. A motion for postponement, whether written or oral, shall at all times be accompanied by the original official receipt from the office of the clerk of court, evidencing payment of the postponement fee under Section 21, letter B, Rule 1 to 141, to be submitted either at the time of the filing of said motion or not later than the next hearing date. The clerk of court shall not accept the motion unless accompanied by the original receipt. Section 13. Dismissal with prejudice. Subject to the right of appeal, an order granting a motion to dismiss or an affirmative defense that the cause of action is barred by a prior judgment or by the statute of limitations, that the claim or demand set forth in the plaintiff's pleading has been paid, waived, abandoned, or otherwise extinguished, or that the claim on which the action is found is unenforceable under the provisions of the statute of frauds, shall bar the refiling of the same action or claim. Rule 16. Motion to dismiss. Rule 17. Dismissal of actions. Section 1. Dismiss upon notice by plaintiff. A complaint may be dismissed by the plaintiff by filing a notice of dismissal at any time before service of the answer or of a motion for summary judgment. Upon such notice being filed, the court shall issue an order confirming the dismissal. Unless otherwise stated in the notice, the dismissal is without prejudice, except that a notice operates as an adjudication upon the merits when filed by a plaintiff who has once dismissed in a competent court an action based on or including the same claim. Section 2. Dismissal upon motion of plaintiff. Except as provided in the preceding section, a complaint shall not be dismissed at the plaintiff instance, save upon approval of the court, and upon such terms and conditions as the court deems proper. If a counterclaim has been pleaded by the defendant prior to the service upon him or her of the plaintiff's motion for dismissal, the dismissal shall be limited to the complaint. The dismissal shall be without prejudice to the rights of the defendant to prosecute his or her counterclaim in a separate action unless within 15 calendar days from notice of the motion, he or she manifests his or her preference to have his or her counterclaim resolved in the same action unless otherwise specified in the order. A dismissal under this paragraph shall be without prejudice. A class suit shall not be dismissed or compromised without the approval of the court. A class suit shall not be dismissed or compromised without the approval of the court. Section 3. Dismissal due to fault of plaintiff. If, for no justifiable cause, the plaintiff fails to appear on the date of the presentation of his or her evidence in chief of the complaint, or to prosecute his or her action for an unreasonable length of time, or to comply with these rules or any order of the court, the complaint may be dismissed upon motion of the defendant or upon the court's own motion, without prejudice to the right of the defendant to prosecute his or her counterclaim in the same or in a separate action. This dismissal shall have the effect of an adjudication upon the merits, unless otherwise declared by the court. Dismissal of counterclaim, cross-claim, or third-party complaint. The provisions of this rule shall apply to the dismissal of any counterclaim, cross-claim, or third-party complaint. A voluntary dismissal by the complaint by notice as in Section 1 of this rule shall be made before the responsive pleading or a motion for summary judgment is served, or if there is none, before the introduction of evidence at the trial or hearing. Rule 18. Rule 18. Section 1. Rule 18, pre-trial. Section 1. When conducted, after the last responsive pleading has been served and filed, the branch clerk of court shall issue within 5 calendar days from filing a notice of pre-trial which shall be set not later than 60 calendar days from the filing of the last responsive pleading. Section 2. Nature and purpose. The pre-trial is mandatory and should be terminated promptly. The court shall consider a. The possibility of an amicable settlement or of a submission to two alternative modes of dispute resolution. B. The simplification of issues. C. The possibility of obtaining stipulations or admissions of facts and of documents to avoid unnecessary proof. D. The limitations of the number and identification of witnesses and the setting of trial dates. E. The advisability of preliminary reference of issue to a commissioner. F. The propriety of rendering judgment on the pleadings, or a summary judgment, or of dismissing the action should a valid ground thereof be found to exist. And G. The requirement for the parties to mark the respective evidences, if not yet marked, in the judicial affidavits of their witnesses. 2. Examine and make comparisons of the adverse parties' evidence vis-a-vis the copies to be marked. 3. Manifest for the record stipulations regarding the faithfulness of the reproductions and the genuineness and due execution of the adverse parties' evidence. 4. Reserve evidence not available at the pre-trial, but only in the following manner. 1. For testimonial evidence, by giving the name or position and the nature of the testimony of the proposed witness. 2. For documentary evidence and other object evidence, by giving a particular description of the evidence. No reservation shall be allowed if not made in the manner described above. H. Such other matters as may aid in the prompt disposition of the action. The failure without just cause of a party and counsel to appear during pre-trial, despite notice, shall result in a waiver of any objections to the faithfulness of the reproduction's mark, or other genuineness and due execution. The failure without just cause of a party and or counsel to bring the evidence required shall be deemed a waiver of the presentation of such evidence. The branch clerk of court shall prepare the minutes of the pretrial, which shall have the following format. Section 3. Notice of pretrial. The notice of pretrial shall include the dates respectively set forth: A. Pretrial, B. Court Annex Mediation, and C. Judicial Dispute Resolution if necessary. The notice of pretrial shall be served on counsel or on the party if he or she has no counsel. The counsel served with such notice is charged with the duty of the notifying of the party represented by him or her. Non-appearance at any of the foregoing settings shall be deemed as non-appearance at the pretrial and shall merit the same sanctions under Section 5 hereof. Section 4. Appearance of parties. It shall be the duty of the parties and their counsels to appear at the pre-trial, court annex mediation, and judicial dispute resolution if necessary. The non-appearance of a party or counsel may be excused only for acts of God, force majeure, or duly substituted physical inability. A representative may appear on behalf of a party, but must be fully authorized in writing to enter into an amicable settlement, to submit to alternative modes of dispute resolution, and to enter into stipulations or admission of facts and documents. Section 5. Effect of failure to appear. When duly notified, the failure of the plaintiff and counsel to appear without valid cause when so required, pursuant to the next preceding section, shall cause the dismissal of the action. The dismissal shall be with prejudice unless otherwise ordered by the court. A similar failure on the part of the defendant and counsel shall be cause to allow the plaintiff to present his or her evidence ex parte within 10 calendar days from termination of the pre-trial, and the court to render judgment on the basis of the evidence offered. Section 6. Pre-trial brief. The parties shall file with the court and serve on the adverse party in such manner as shall ensure the receipt thereof at least 3 calendar days before the date of the pre-trial. The respective pre-trial brief which shall contain, among others, A concise statement of the case and the reliefs prayed for. B. A summary of admitted facts and proposed stipulations of facts. C. The main factual and legal issues to be tried and or resolved. D. The propriety of referral of factual issues to commissioners. E. The documents or other object evidence to be marked stating the purpose thereof. F. The names of the witnesses and the summary of the respective testimonies. And G. A brief statement of points of law and citations of authorities. Failure to file the pretrial brief shall have the same effect as failure to appear at the pretrial. Section 7. Pretrial order. Upon termination of the pretrial, the court shall issue an order within 10 calendar days which shall recite in detail the matters taken up. The order shall include A. An enumeration of the admitted facts. B. The minutes of the pretrial conference. C. The legal and factual issues to be tried. D. The applicable law, rules, and jurisprudence. E. The evidence mark. F. The specific trial dates for continuous trial, which shall be within period provided by the rules. G. The case flow chart to be determined by the court, which shall contain the different stages of the proceedings up to the promulgation of the decision and the use of the time frames for each stage in setting the trial dates. H. A statement that the one-day examination under AM number 03-1-09-SC guidelines for pretrial shall strictly be allowed. And I. A statement that the court shall render judgment on the pleading or summary judgment as the case may be. The direct testimony of the witnesses for the plaintiff shall be in the form of judicial affidavits. After the identification of such affidavits, cross-examination shall proceed immediately. Postponement of presentation of the parties. Witness at a scheduled date is prohibited, except if it is based on acts of God, force majeure, or other substituted physical inability of the witness to appear and testify. The party who caused the postponement is warned that the presentation of its evidence must still be terminated within the remaining dates previously agreed upon. Should the opposing party fail to appear without valid cause stated in the next preceding paragraph, the presentation of the scheduled witness will proceed with the absent party being deemed to have waived the right to interpose objection and conduct cross-examination. The contents of the pretrial order shall control the subsequent proceedings unless modified before trial to prevent manifest injustice. Section 8. Court Annex Mediation. After pretrial and after issues are joined, the court shall refer the parties for mandatory court annex mediation. The period for the court annex mediation shall not exceed 30 calendar days without further extension. Section 9. Judicial Dispute Resolution. Only if the judge of the court to which the case was originally raffled is convinced that the settlement is still possible, the case may be referred to another court for judicial dispute resolution. The judicial dispute resolution shall be conducted within the non-extendable period of 15 calendar days from notice of failure of the court annex mediation. If judicial dispute resolution fails, trial before the original court shall proceed on the dates agreed upon. All proceedings during the court annex mediation and the court judicial dispute resolution shall be confidential. Section 10. Judgment after pre-trial. Should there be no more controverted facts and no more genuine issue as to any matter as to any material act oh shit as to any material fact or an absence of any issue, or should any answer fail to tender an issue, the court shall, without prejudice to a party moving for judgment on the pleadings under Rule 34 or summary judgment under Rule 35, motu proprio include in the pretrial order that the case be submitted for summary judgment or judgment on the pleadings without need of position papers or memoranda. In such cases, judgment shall be rendered within 90 calendar days from termination of the pretrial. The court, the order of the court to submit the case for judgment pursuant to this rule shall not be the subject to appeal or certiorari.